This is Protected Thoughts from the Intellectual Property Team at McBrayer. This is an overview of state or federal law and regulation and does not constitute legal advice. Services may be performed by others. For more information, visit mcbrayerfirm.com.
Welcome to Protected Thoughts. I am Mary Lise Paul, and I'm here with Bruce Paul.
Good afternoon.
It's been a while.
Yeah, an embarrassing amount of gap time, but hopefully we can make up for it.
I think so. Last we left off, we were talking about public domain day way back at the beginning of the year. January 1st, 2025 is Public Domain Day when works enter the public domain. So that means that works that enter the public domain are free for everyone to copy and share and build new works from.
Last year, Mickey Mouse came in, and that made a lot of news. Winnie the Pooh came in last year. That made a lot of news. This year, a lot of literary works. We have The Sound of the Fury, A Farewell to Arms.
There were some Mickey Mouse animations. I think Mickey Mouse's first talking appearance in the Carnival Kid film came in. And there was also the skeleton dance animation. Are you familiar with that one, where the skeletons dance around?
Well, Mary Elise, you were just sitting on the couch across from me when Stella and I were watching that the other day. So, yes, we are familiar with that.
I was. I forgot about that. Yes. I think that most people are familiar with the skeleton dance if you are a Disney fan, but it's pretty cute.
Popeye's made it. Tintin is in the public domain this year.
You know what else is in the public domain that is a favorite of mine is the song Singin' in the Rain. Not the film, but the song Singin' in the Rain.
You gonna sing it?
I'm singing in the rain, just singing in the rain.
An American in Paris, do you know that, by George Gershwin?
I cannot sing that one for you, but am familiar.
It has Paris in the name, so I'm confident you love it.
True, I do. Ain't Misbehavin'.
Yeah. I mean, there's a lot of stuff that if I were more cultured, I would be able to wax poetic a little more about, but always fun to look back at what's in the public domain and imagine what's gonna come from different uses of these works.
Yes. Speaking of what's going to come from uses of these works, you mentioned that you saw the film Nosferatu, and you said that had a story about coming from a work in the public domain. Dracula?
So yeah, it's famous. This is a little worn out conversation of something that was kind of a big deal in October, November when Nosferatu was released. Nosferatu famously was created in the 1920s as a reimagination film production from Bram Stoker's Dracula. Bram Stoker's widow didn't like it, filed a lawsuit claiming copyright infringement. The judge sided in favor of Bram Stoker's widow, and not only ruled that the movie could not be released, viewed, but ordered everything thrown away, destroyed. And so at the time it was I'm sure that there were copies of it, versions of it available to be seen, but it's shocking that it's not like 2025 when, there are probably bootlegs of it being thrown around that you can find somewhere on archive.org, like I can find the Grey Album by Deadmau5.
Was that where you found it?
Yeah. Oh. You can find the Grey Album. But anyway, so wasn't released, but then it was recreated in the 1960s. Nosferatu was. Not seen it, have nothing to report on it, but I did see the 2024-2025 version of it, and it is outstanding.
That is what you tell me. I am not a scary movie fan, so I have not and will not be seeing this. But did you say there's a sequel in the works?
I do not know that. I hope so. I don't know.
Oh, okay. I may have just made that up. I'm not sure. So you mentioned that the lawsuit involving Dracula and Nosferatu involved Bram Stoker's wife. In more recent times, in more recent television, one of my favorite news shows is also involving a lawsuit with an author's wife. The Pit. Can we talk about The Pit?
Indeed.
Is it one of your favorite new television shows as well?
It's quite good. It's quite good. We were, we started to watch it. I think you saw some blood and shut down, and so we pressed stop. That then I came back to it on my own and assured you that it would be okay. And you agree it's okay, right?
Oh, it's fantastic. I can't wait for season 2. As you know, from all of the time that we have spent in the hospital with Stella, have a little bit of, do I want to watch this? Do I not? Is it going to be difficult? But when she started watching, can't stop watching. It was so good. Now, Michael Crichton's wife, so the Michael Crichton estate, has sued Warner Brothers, but not for copyright infringement.
Yeah, Michael Crichton's wife and others. There are other defendants. Yeah, Michael Crichton's widow sued Warner Brothers and some others, alleging not copyright infringement, but breach of contract, breach of implied contract of good faith and fair dealing, and intentional interference with contractual relationships or relations. As I understand the fact pattern, the estate was in negotiations with Warner Brothers to create an ER reboot. ER, famous 1990s Thursday night television.
Did you watch that when it was on live?
Kind of, sort of. It was right after Friends, and in my era, everyone watched Friends.
I watched Friends.
Most people stuck around for ER.
But I remember I never watched ER, although I had some friends that watched ER. I think I went to bed after Friends was over.
George Clooney's so handsome. But they were in negotiations for a reboot of ER, and then those negotiations stalled, went sideways, not sure what exactly happened, and poof, The Pit came out and is a smash success. Did not allege copyright infringement. The case is not brought in federal court as a copyright infringement would be. It's brought in Los Angeles, California.
Why do you think they didn't allege copyright infringement?
Hard to know what that litigation strategy is, but probably a lot of the same reasons why the defendants filed an anti-SLAPP motion in response to the complaint, alleging fair use. There's nothing remarkable about a hospital drama. We have Grey's Anatomy. We have Chicago Hospital Show, whatever that's called. We have General Hospital. What other hospital shows do we have in the past? A lot of there's definitely a hospital drama trope. Scrubs.
Oh, Scrubs was a great show. I loved Scrubs.
Comedy though, right?
Yes, but still it takes place in a hospital.
Never seen it. But side note, anti-SLAPP motion. Anti-SLAPP statutes exist in certain states. I don't think we have one in Kentucky. Definitely have them in California where this was filed. And basically the premise of an anti-SLAPP statute is a defendant argues that the plaintiff is bringing this suit to attempt to prevent the defendant from exercising its rights of free speech. And in California, it is definitely the law that the creation of movies, the creation of music, the creation of anything is free speech. Mm-hmm. And so by trying to shut this lawsuit, or by trying to shut down the production of The Pit, the defendants filed a motion saying that the Crichton estate was violating their free speech rights. It was an unsuccessful motion. The court found that, yes, it was a violation of their free speech, but once the defendant clears that hurdle in the motion, the burden shifts to the plaintiff to show that it is likely to succeed. Interestingly, the order in favor of the plaintiff does not find that they are likely to succeed, but it finds that the claims, the breach of contract, the implied contract, and the intentional interference claims are, quote, not without merit. So the decision sort of lowered the bar a little bit in ruling in favor of the plaintiffs. It does not in any way, shape, or form suggest that the plaintiffs will ultimately win, just that the plaintiffs overcame this procedural hurdle. Circling back to your question, why wasn't it filed in federal court? I would assume because there are all sorts of fair use defenses. This is, again, a hospital drama that is a tried and true production with people sitting at home watching TV.
There are some arguments in the litigation, though, that the shows aren't substantially similar, aren't there?
Yeah. So in the anti-SLAPP motion, they argued that none of the characters are the same. The new one takes place in Pittsburgh. The old one took place in Chicago.
So you're tying in copyright law, even though this isn't a copyright claim. Anderson, state court versus federal court.
Right. Absolutely. You know, none of the characters have the same names. There's one actor, Noah Weil, who is his quotes on the issue are he's very, very diplomatic in saying that it's unfortunate that the estate is bringing this lawsuit, and he was hoping it wouldn't come to this, but he's being very diplomatic about it while defending the pit and saying it's a different time, a different play. I think they actually pointed out in the case that in ER, his character was a highfalutin, quote unquote, waspy rich kid going through a residency, whereas in the pit, he's the attending physician, so he is the elder of the space, and he's a tough, crusading sort of fellow who spent time, I think, in the Doctors Without Borders program. So a very different, a different light even on that common actor that's in the two shows.
I think one of the arguments the Crichton estate makes is that his character in the pit is supposed to be a revival of Dr. Carter, but if you've watched both shows, I don't see that argument as ringing true. I don't see him as Dr. Carter in a later time.
Right. Well, his name's not Carter.
Well, there's
He's not
that.
in Chicago.
Sure, he happens to be Noah Weil, but that's kind of where the similarity, and in a hospital, but that's where the similarity ends for me.
Right. And a lot of that stuff gets into, I know you wanted to touch on the concept of cinefaire, and I'm probably mispronouncing that because I'm pretty terrible at French. But it's the concept in copyright law of that there are certain things that when a song is created, when a production, when a movie, when a story is created, there are certain natural attributes that by default have to be in that story. Generic
themes are necessary or indispensable for the conveyance of particular ideas.
Right. That's the more formal definition for sure. And so, in the hospital context, an attending, hot times and cold times when people are coming through, residents making mistakes, people making off-color jokes about, someone who's been injured. Those are sort of cinefaire types of circumstances that aren't really protectable because that's a natural backdrop to any sort of hospital drama.
The backdrop of the hospital, even, and the clothing of the hospital.
Yeah. I will share in brushing up on cinefaire today. My favorite example of cinefaire is a case involving Fort Apache. There's a movie called Fort Apache and then a movie called Fort Apache, The Bronx, where the court where the plaintiff argued, both the book and the film begin with a murder of a black and white policeman with a handgun at close range. Both depict cockfights, drunks, stripped cars, prostitutes, and rats. Both feature as central characters third and fourth generation Irish policemen who live in Queens and frequently drink. Both show disgruntled, demoralized police officers in unsuccessful foot chases of fleeing criminals, which the court, the Second Circuit, said all were sine faire. So there you go. Irish police officers, cockfights, drunks, strip cars, prostitutes, and rats. You can see how the Second Circuit feels about the Bronx.
That is unkind.
1986.
This is not necessarily the same sine faire, but it ties in with the idea that themes are not copyrightable or protectable. So you haven't seen the show Yellow Jackets, have you?
I have not.
I didn't think so, but I know that when you're running on the treadmill, sometimes you watch a series of shows. We don't always watch the same TV. So I thought I'd ask. And it's about, I think, soccer. So you tend to also watch soccer shows. So.
Yes, I watched the soccer matches on the pitch.
Okay, but you watched Ted Lasso.
Sure.
Okay. There was a lawsuit involving the show Yellow Jackets, where Showtime and Lionsgate Entertainment One were sued for copyright infringement over the series Yellow Jackets. The plaintiffs in the lawsuit claimed that Showtime and Lionsgate Entertainment One stole ideas from a 2015 film called Eden. Have you seen or heard of this film, Eden?
I haven't, but I read Lord of the Flies, and it's all the same. Oh, wait, no, but I know that Eden is the same storyline, but it's a men's soccer team, right?
Allegedly. So there are the same themes of competition, tribalism, trying to escape a disaster scenario, much like that. I believe that Yellow Jackets takes place in the Canadian woodlands and Eden takes place on an island, an uninhabited island. So there's a bit of a difference there. But I think in Yellow Jackets, is it some sort of a crash where the soccer team lands in Canada and they're trying to escape, but the players and coaches have to fight for their lives against these harsh elements, and then they have scarce and then ultimately dwindling resources. They have starvation, and then you have this psychological toll of being isolated and starving. And so predictably, what's going to happen? Tensions rise and the teams are pushed to their limits ultimately. I think it's still on Showtime. I've not watched it. It's not a typical TV that I would watch, but I think it's really popular. Showtime and Lionsgate prevailed.
Yeah. Same stuff. That's definitely an archetype story. You know, we have an entire show called Survivor that's been going on however many seasons that is much of the same thing. Your parents' favorite show, Naked and Stranded.
Naked and Afraid.
Naked and Afraid.
I don't think it's their favorite show, but I think my dad does enjoy watching that show. Mm-hmm.
Uh-huh.
They
love walking in and seeing Naked Afraid on their big screen TV.
They enjoy Maine Cabin Masters more.
Yeah. Anyway, the plaintiff in that case was unsuccessful because it's again, not that Yellow Jackets isn't creative. It is creative in its own sense. It's copyrightable in its own sense as a production. No one could create a substantially similar show involving a women's soccer team undergoing the thing called the Wasps. And, that might be different, but just generically speaking, this is a tale as old as time. And it's, the claims in the complaint were not valid, found to not be valid. And not only is this fight for survival among people a tried and true, archetype, but it's inspired by a famous plane crash in forget the year, but an Uruguay soccer team crashed in the Andes, and I think Yellow Jackets is said to be inspired by that story.
You mentioned earlier A Tale as Old as Time, which famous Disney quote, you have me thinking about Disney. So Disney just prevailed in a legal battle over Moana, but still faces one with Moana 2. Our daughter Stella is a big Moana fan, so we have seen Moana and Moana 2. But Moana has been sued by...
Disney has been sued by the creator of this film, Bucky the Surfer Boy, for copyright infringement. Mr. Woodall alleged that Disney infringed the copyright in Bucky the Surfer Boy for both Moana and Moana 2. Now, Disney prevailed in Moana 1. The court found that Disney did not have access to Bucky the Surfer Boy in the creation of Moana, and the litigation for Moana 2 is still pending. Yeah, so the access issue is kind of a deep cut. In copyright cases, everyone sort of understands the idea of a creative work is protectable. Everyone understands that there are certain concepts of fair use. Everyone knows that there are limitations to copyright protection, as we were discussing earlier with Public Domain Day. But the idea of access is an often ignored component of any copyright claim, where if I had the idea of something and I wrote it down on a piece of paper and I shared it with my 10 best friends in high school, and that was that, and then Disney comes out and creates something similar, I don't get to sue them for copyright infringement because I would have to show that my idea was readily accessible. And in this case, I don't know the details of Bucky the Surfer Boy. I've not read up on the case or looked at the trial transcript, but my understanding is that it was a fully developed concept. There is art to it. I believe I've seen the art, but the jury determined that it wasn't readily accessible. It wasn't out there for anyone to just copy and take and use. And so, yes, access to the pre-existing idea is an often overlooked element of any copyright claim.
Yes, apparently work on Moana began in 2011, and Moana was inspired by Herman Melville. Did you know that?
Did not. Don't know anything about it other than The Rock's involvement. And the soundtrack of Moana 2 is far inferior to the soundtrack of Moana 1.
There's just really such a high bar for Moana 1. The film is fantastic. The soundtrack is fantastic. I think the more you listen to the Moana 2 soundtrack, the tunes get catchier.
Yeah, well, the non-involvement of a fellow by the name of Lin-Manuel Miranda probably had something to do with the with the better soundtrack in 1 than 2. A doorman in the episode of The Sopranos in season 2, I believe. Crazy. It's, when you're up late working, watching Sopranos in the background, and you look up right as the credits are coming on and you see his name as a doorman. It's pretty crazy stuff.
Okay, the last thing I want to talk about today comes back around to deepfakes. We've talked about deepfakes on the podcast before, and just this week, the House passed the Take It Down Act, which criminalizes the non-consensual sharing of sexually explicit images of others and requires companies, online service providers, websites to promptly remove reported images.
Yeah. In 2025, I wasn't sure that virtually unanimous support for any legislation was possible. Heck, I didn't know Congress was still passing laws in 2025, but they found an issue that they could all agree on. And who among us isn't in favor of this legislation. That said, I think there could be some trouble with this.
Well, first, hold on. It passed 409 to 2.
Yeah, it's I think Melania Trump was a big voice in this. I know that it had bipartisan support. And I think, obviously, it is a protection that is necessary. You know, we know that people are being bullied. We know that people are taking advantage of pictures and sexually explicit images, both real and artificially generated.
Right. And this bill, we didn't say this in the beginning, but this legislation protects not only real photos and videos, but also AI generated images, so deepfakes.
It's terrific in its intent. But I do think that there could be some questions where people use it, perhaps abuse it in a way that it's not intended. I mean,
tell me more.
So, I could be super boring and read the actual text of it, but I will do a shortcut and just talk about the congressional office's summary of it. It says, quote, "The bill prohibits the online publication of intimate visual depictions." Visual depictions is a defined term, so it's narrow in scope. I will invite the audience to go read that because I am definitely not going to read that onto a podcast. But the depictions of, one, an adult subject where publication is intended to cause or does cause harm to the subject, and where the depiction was published without the subject's consent, or, in the case of an authentic depiction, was created or obtained under circumstances where the adult had a reasonable expectation of privacy. The second situation is where a minor subject where publication is intended to abuse or harass the minor or to arouse or gratify the sexual desire of any person. Now, the minor protection is pretty black and white. I don't know why there needs to be language in here that the depiction of the minor is only illegal where it is intended to abuse or harass. If it's a minor, I'm not sure why that variable's there.
Just take it down.
But on the adult side, it's where the publication is intended to cause or does cause. Well, intent, I don't know. I mean, let's back up. What does this law do? This law enables people to send online platforms notices that require them to take photographs down. Online platforms generally are happy to do that. There are many laws that protect them, that make it worth their while to do that. The Communications Decency Act. In the copyright context, there's the Digital Millennial Copyright Act. Lots of laws exist to protect online service providers, online platforms, the Facebooks, the Instagrams, the whatever, and encourage that conduct. They're happy to do that. But in this case, there's an intent element that's weird, or it does cause harm to the subject. It's weird. You know, I think that there are obviously black and white circumstances where this is going to be a no-brainer.
But if you are the reporter, you get to report to the online platform, and if it's causing you harm, it's causing you harm. You report it, it comes down. And I think the time element, while it may be difficult for some platforms to process within 48 hours, I do think if you are the victim of one of these online images, you want it down as soon as possible. So thinking from the perspective of a client who is an online service provider, someone that would have to process this, almost immediately, it may seem like, okay, 48 hours is maybe a long time, but if you're thinking about it from the perspective of your child, 48 hours seems like too much time. So it's an interesting kind of balance there.
Yeah. On the platform front, and then again, this is just the summary. This isn't the actual text. So room for grace on this if it's not entirely correct, but it says separately covered platforms must establish a process through which subjects of intimate visual depictions may notify the platform of the existence of and request removal of an intimate visual depiction, including that the subject was published without the subject's consent. And covered platforms are defined as websites, online services, or applications that primarily provide a forum of user-generated content. So you've got, in addition to what we were talking about earlier, you've got Reddit, you've got, I don't know, what are some other platforms? Substack would be one. There's going to be no new terms of use. There's going to be, all of these platforms are going to create new policies, new mechanisms whereby people can go and click on a link and it's probably going to generate an email. There's going to be a takedown notice that can be sent. And, I don't think it'll be a big deal, but, like any new legislation, it's just some of the language is a little bit head scratching.
Yeah, some speech advocates have warned that the measure could chill the freedom of expression. They're concerned that it could force the removal of legitimate images. But we talked about this a bit earlier, and as you mentioned, the way that the bill is so narrowly written with what constitutes a sexually explicit image, I don't have those same concerns.
Yeah, that's the part that I am not. I'm not terribly interested in reading, but let's just say that under 15 USC section 16, under United States Code 15 USC 6851, the definition of intimate visual depiction is pretty graphic. So it is pretty narrowly tailored. Genitals, sexual bodily fluids. It's pretty narrow. It's pretty narrow. So, by the same token, a back of a female without that is suggestive may not strictly qualify under this. That's where the gray area is. That's where I'm not saying I oppose it. I'm not saying it's bad legislation. I'm just saying I think that there is no vetting. Let me also say this. There's no vetting of the content that's requested to be taken down. No online service provider is going to look at it and,
You're just taking it down if it's reported.
Yeah, you're just
which I think is maybe where the concern is coming in, that people are over-reporting.
Right. And I think that's definitely the case, that over-reporting will happen. Maybe that's fine. I don't think that there's going to be a line of people suing over this issue, over-reporting. But I do think that, this is a criminal law. Actually, I don't know if it is a criminal law. I need to check on that. This is a federal statute, and federal statutes have consequences if you don't follow them. And so I think that's just potentially there are going to be some issues that arise.
It's a good step in the right direction of protecting people from cyberbullying and sexually explicit images and deepfakes. So happy to see bipartisan support for this bill.
For sure. Oh, and the other thing on the positive note is, in addition to, bravo to Congress for doing something. Good job. But not only that, this is really something that should be nationalized, because the last thing the United States needs is a patchwork of statutes, state by state by state, where online platforms are going to have to figure out which state this is in, which rules apply, be subject to different punitive schemes depending on where the person is sitting. If Indiana versus Kentucky versus California versus New York, it is important for these sorts of things in the online environment to be federal statutes for uniformity purposes.
I agree. Anything else you want to talk about today?
Nope.
All right. Well, that is enough for this episode. Thank you for listening to our podcast. Remember, we're lawyers, but we are not your lawyers. We just love talking about the law. We will see you back here next time on Protected Thoughts. Check us out on mcbrayerfirm.com. And if you are attending the International Trademark Association annual meeting, reach out. We'd love to meet you. See you next time.
See you later.
All content copyright 2025 McBrayer PLLC. All rights reserved.